Nationstar Mortgage versus Charles Young et al. Gentlemen, each party will have 15 minutes to present oral argument. As you know, as appellant, you will have up to 5 minutes for rebuttal. If you wish to reserve any time, just let me know.
Okay, I would like to reserve 3 minutes, please.
3? Okay, very well. We've read the briefs. We're ready when you are.
Good morning, Your Honors, and may it please the Court. My name is John Kof, and I represent Nationstar, the appellant in this matter. We are here again. We were here once before. The case is basically the same, except this time the Court has the benefit of the trial court's specific review and analysis of the waiver issue on the res judicata defense, which was the defense that ended up carrying the day for the appellants in the court below on summary judgment. Because we are here on appeal from summary judgment, we have a de novo standard of review. In short, my client filed a lawsuit to try to dispute and challenge the validity and extent of a mortgage lien that was junior in terms of recording timing to my client's mortgage interest, or I'm sorry, my client's predecessor's mortgage interest. And so a quiet title action was filed. The other mortgage holders, the appellees in this case, the Youngs, they opposed and said, you can't be disputing our lien in this case because guess what? Our daughter, who gave us our mortgage, filed bankruptcy, and the validity of our lien was decided over there in the bankruptcy court. My client and trial counsel that handled this before me at the trial court level argued, no, if you look at the bankruptcy record, nobody decided anything about the validity or extent of the lien. All that happened there was that the mortgagor scheduled your claim. She then had a plan that was implemented, which said specifically in the plan, nothing here is actually determining anyone's claims. And she went through her plan, and here we are. There was no adjudication, and that's kind of the heart of this case on the merits of the res judicata, is there was no adjudication. But the other thing that my client argued in the court below was, you don't have to get to the merits of that question, which is kind of interesting and more intricate and complicated because it's res judicata and you got bankruptcy and it's harder. The much easier way that we believe the trial court should have dispensed with the res judicata defense was to say, Mr. and Mrs. Young, you had 2 chances to plead this defense of res judicata. In the state of Ohio, we have Civil Rule 8. Civil Rule 8 says, you don't plead an affirmative defense, you don't get an affirmative defense. You had 2 opportunities to plead, and in neither opportunity did you plead this defense. The appellate record's clear, Your Honors, that there's no dispute, they didn't plead it. At one point they had raised in the prior appeal an argument that, well, we did plead estoppel, and we did plead waiver, and so that's close enough to res judicata. But I think that issue is now off the table. It's pretty clear that the case law says, no, we don't accept that. You have to plead your specific defense. You can't say, well, it's close enough to one of the other affirmative defenses that you can get it in that way. So, in the prior case, this court said, trial court, we don't see that you explicitly, at least in your written decision and entry, passed upon this question of waiver of the res judicata defense. Would you please consider the Jim's Steakhouse case from the Ohio Supreme Court, and then an earlier case called Freeman from the Ohio Supreme Court, and help us to reconcile and understand these cases and tell us what you think the law is in this regard. The trial court went through those cases, disagreed with the approach that my clients had taken in the briefing before this court in the prior appeal, and said, I think that notwithstanding the Jim's Steakhouse decision, which postdates Freeman, and notwithstanding the implementation of Civil Rule 8, I think that the law should be that you can raise res judicata for the first time in a summary judgment brief, even if you've had opportunities to plead it and didn't do it. We respectfully submit that that's an error of law. We don't create special types of affirmative defenses that get special treatment. All affirmative defenses need to be pled in the responsive pleading that you want to assert, or you waive them. it's kind of unusual to think that we would separate out res judicata. What's special about res judicata? That we're going to treat it different from all of the other affirmative defenses. And so for res judicata, we're going to create a special law that says, for that one, for some reason, some unarticulated reason, that one's okay to not plead and just raise by summary judgment. It doesn't make any sense. That shouldn't be the law. And it isn't the law we respectfully submit. I think when you actually go through the case law on the subject of waiver, it becomes clear that some of the words from prior opinions that some other courts of appeals, not this court, have relied upon to say, oh yeah, you can raise res judicata in summary judgment for the first time. They're seizing on dicta without having painstakingly, I submit, Your Honor, gone through these decisions. In my brief, I went through kind of the seminal case that kind of has gone down, led to a bunch of cases saying, oh, you can raise this for the first time on summary judgment. And I explained how, in that case, the Sixth District had said, well, first of all, we think maybe you waived it because the Civil Rule 8 came into play. But assuming, for sake of argument, that you hadn't waived it, you had to have asserted it in your motion. Well, we're going to assume you asserted it in your motion. Let's just get to the merits. Oh, guess what? On this record, there's no facts that show res judicata. So when you actually go back and reread the opinions, and I put it in painstaking detail in the briefs, and I won't belabor it here at argument unless you'd like to discuss it in more detail. But some courts have seized on some bad language and some dicta. And it just doesn't make sense. Like I said, why would we create a rule that allows a party to assert one of 20 or 30 different affirmative defenses that the state of Ohio allows to be asserted in a case? Why would we exclude that from the application of Civil Rule 8? It just doesn't make any practical sense. So we respectfully submit that when you read the case law, Jim Steakhouse said, hey, you didn't plead, you lost your res judicata defense. And that came out after the framing case and the dicta in the framing case that opposing counsel and his clients were relying upon. So we think that the clean, heart-shot approach for this court to take to reverse the trial court below is to decide there was a waiver of the res judicata defense. They had two chances to plead it. They didn't plead it. The court shouldn't have granted summary judgment to them on an unpled defense. I would note that even when we went back on remand, there were no additional motions to supplement their pleading or amend their pleading to try again to slip in the defense, although I think maybe it would have been inappropriate at that point. But they did get remanded and did go back down. There was, again, no effort to try and amend their pleading at that stage. So here we are again. The more difficult question, but I think there's an intuitive response on the merits of res judicata. It's more difficult because there's more rules and cases and things to have to deal with. But if you just think about it from this perspective, if no judge in any courtroom ever sat down and looked at their mortgage and said, oh, someone's contesting this, I've decided it's a valid mortgage. If no judge has done that, why are we going to let res judicata reach up and say, you can't challenge that? And that's kind of the heart and the obvious answer in this case. It's, wait a minute, nobody decided anything about the Young's mortgage lien. Nobody filed a proof of claim in the bankruptcy court to question the lien. Nobody filed an adversary proceeding in the bankruptcy court to question the lien. They rely on the confirmation order of a bankruptcy plan. Well, nothing in the plan says anything about their lien. They're not even mentioned in the plan. And if you look at the order, which would be the thing that we look to for res judicata, right? We look to the judgment, the decision of the court. It says nothing about their mortgage. And in fact, it has a provision in it that says, hey, we're just telling you what the classification of the claims are and how they're going to be treated. We're not saying they're valid. This is just the classification in the plan. If you want to talk about and fight about whether the liens or claims are valid, you got to do more. So if you are a creditor and you want to have a secured payment paid by the classification of the plan, you've got to file a proof of claim. That starts the process to decide whether or not it's a valid claim. If that process has never started, no one's adjudicating anything about that claim. The only thing that's been adjudicated is the plan, which is just classifications of claims. It doesn't deal with any particular claims. there was no decision made by the bankruptcy court in this case that said that their mortgage is valid. In fact, the record shows the Youngs, they didn't even know that they had a mortgage until after the bankruptcy plan was confirmed. A year after the bankruptcy plan was confirmed. This is because their daughter didn't tell them that she gave them a mortgage. The record shows that she took out this mortgage days before this foreclosure action got filed. She gave it, she recorded it, she didn't deliver it, which is a big problem in Ohio, because if you don't deliver a mortgage, guess what? It's not effective. The mortgagees never received it, and they didn't do anything, they didn't even know about it. I mean, how could they have adjudicated something in the bankruptcy court when one party to the mortgage isn't even there? I mean, the borrower is the one that scheduled this, and there's nothing in the bankruptcy rules or the code that says if a borrower schedules a claim, you better show up and start some proceeding, or else, you'll never be able to challenge, or dispute the claim ever again. And that's kind of what they're offering. What's interesting is in their brief, they admit lien issues, they just pass through the bankruptcy court unless they're specifically addressed in the bankruptcy court. And that's right. I mean, a borrower schedules a mortgage, a secured claim, and the plan's done, and everyone goes away, and guess what? The secured creditor shows up again and says, hey, we're post-bankruptcy, and I still want to enforce my lien that survived the bankruptcy. The borrower isn't precluded from challenging the lien at that point. No, the borrower stands up, we have a foreclosure action, the borrower complains about standing and all the other things that they complain about. We wind up here again, but we don't go raise judicata because you've scheduled a claim and you didn't dispute it in your bankruptcy, so now we just get to come in. Raise judicata just doesn't apply. I think if you just come back to the idea of, did the judge actually decide anything about their mortgage? That should drive the analysis, and everything else I think falls into place. And I'll reserve any balance of time I may have left.
You will have 3 minutes.
Thank you.
Good morning, Your Honor. May it please the court, I'm Rob Stefanson from the law firm of Ice Miller, representing Gertrude and Charles Young, who are the appellants in this matter, the defendants in the court below. There was a whole lot in an appellant's presentation that I want to get to with respect to the res judicata issue. And he relies a lot in his argument on Jim Steakhouse and the dicta in that case concerning the pleading of an affirmative defense under Rule 8C, and the failure to plead that any defense would be a waiver of that. Counsel does not address the cases which interpret Jim Steakhouse and which are cited in our brief, in particular the EBP versus 623 West St. Clair Avenue case, which is a Cuyahoga County case decided in 2010, as well as the EPDM case, which is relied upon by the trial court in the second opinion with regard to the remand that this court issued after this court asked the trial court to look at the issue of the analysis in Jim Steakhouse. In particular, in the EBP case, the court looked at the specific issue which is raised here, which is when you fail to plead a defense of res judicata in your answer, can you raise it in a motion for summary judgment for the first time? And the court said yes, and I won't go through the analysis in that case because of course the case is attached to our brief, but the court went through the Jim Steakhouse decision as well as the cases that were cited by the appellant in his brief, and came with the same analysis as the trial court did here, which is, in this case, you can raise res judicata as a specific affirmative defense for the first time in a motion for summary judgment. I would point out to the court, too, that while counsel says that there should be no reason why this defense is different than any other defense which is noted in Rule 8C, what I would note is there is a provision in the rules that allow parties to amend their pleadings even at trial when the evidence at trial would support a defense. That's under Rule 15.
But he says that given the opportunity that your client didn't move to amend its answer at any time.
Your Honor, I would like to address that, and I think at some point There is some context in this case that needs to be taken into, the court should listen to. When they filed this case, when the plaintiff filed this case, neither counsel or I were on this case. My clients were actually pro se. They got a copy of the complaint for quiet title. By way of background, Your Honors, my clients are in their 70s. They're Stephanie Young's parents. She gave them this mortgage in order to secure the payment of money that they advanced to her, that the bank would not advance to her for the completion of this house over on Toplet Drive. She was a home builder, and she wanted to make sure that her parents got paid money that they advanced to her, because this was her and her husband's kind of side business. When they got the complaint, for obvious reasons, they thought that this might go away or they might be able to resolve it, and they didn't hire counsel. And they appeared at the courthouse after filing their own answer for the first time. After that first pretrial, it dawned upon them that they needed to get counsel. And in a haste, I put on an answer because I listened to some of the issues that were raised by them with respect to this mortgage, not knowing some of the facts that were involved in Miss Young's bankruptcy and her husband's bankruptcy a year or two prior, maybe 3 years prior. When I was asked for discovery in this case, we provided plaintiffs' counsel with not only Miss Young's bankruptcy petition schedules, but also a copy of their own motion for relief from stay in that case so they can complete the foreclosure, where plaintiff itself acknowledged that my clients had a mortgage. And at some point it became clear to me that despite the fact that they acknowledged that my clients had a mortgage, that the trustee in the bankruptcy case had not contested the validity of that mortgage for the benefit of unsecured creditors, and the fact that my clients were on record as having a mortgage before their initial foreclosure was ever filed, they decided that they were not going to add my clients as a party defendant in the foreclosure and foreclose the home. Now I say they, and that's not right, because it was their predecessor in interest. It was Aurora Mortgage Services or Aurora Management. It wasn't this lender, but this lender did buy the credit bid, or it was an assignee of the credit bid that the mortgagee had in the foreclosure case. So they took that assignment and they knew about my client's rights, or they should have known at the time they took the assignment that my client was out there on the record and nobody had named them in the foreclosure. So we argued waiver, we argued estoppel, and we went on our way. But at some point, this plaintiff was aware about the bankruptcy case and about their own admissions in the bankruptcy case, and about the fact that my clients were out there in the public record with their mortgage, and nobody had contested the validity of that mortgage. Nobody had added in the foreclosure case. Nobody took the time to give them notice that the property was going to be foreclosed. So they foreclosed it. And then out of the blue, my clients get a quiet title action. Back to your Honor's point. Yes, in my initial answer, I could have raised the res judicata defense. At some point after I realized that Mr. and Mrs. Young, Stephanie Young and her husband, had filed their bankruptcy case, we could have raised it. But we raised it in a motion for summary judgment, and they knew it was coming. And even if we had filed a Rule 15 motion to amend the answer at that point, amendments are freely given based upon the evidence. So the ultimate, to me, is the idea that at some point we were going to be able to raise that defense by way of an amendment. Whether that was going to be a formal motion to amend the answer, whether that was going to be at trial, it was not going to be a surprise to this plaintiff. And yet we're here for the second time. We're here because my clients have a $57,000 mortgage. They're not entitled to any interest or attorney's fees. We're talking about a $57,000 mortgage that they missed, their predecessor missed, and they missed when they did their analysis, when they decided to take the assignment. We're here for the second time after 2 rounds in the trial court, after 2 rounds here, and if this court decides to remand based upon the evidence that's in the record and based upon the facts and the law that's here, we're going to go back and we'll be back again on a $57,000 mortgage because they missed it. And they want my clients to spend the time and effort, and this court to spend the time and effort to deal with these issues on a step-by-step basis because they don't want to admit their mistake. That's it. Now, I apologize, Your Honors, I got off on a little bit of a tangent. The answer is yes. Clearly, if we go back to the trial court, with respect to the remand issue, after this court remanded the first time, my reading of the order was pretty clear. You were asking the trial court to take a look at the briefs that were previously filed and make a determination on Jim's Steakhouse as to whether or not we could properly raise it in a motion for summary judgment. And the trial court properly relied upon EBP, EPDM, and the cases that are cited in the order, and said, yes, you can raise it for the first time in a motion for summary judgment. As to the issue of res judicata, and as to the issue in the bankruptcy case, the trustee could have questioned this mortgage. The trustee's got an obligation to do that for the benefit of unsecured creditors. They acknowledged, their predecessor acknowledged the validity of the mortgage. And what's striking to me, Your Honors, is the fact that this whole case was filed and the theory of their case is included in their brief. The theory in their case is that Stephanie Young provided the mortgage to her parents to defraud creditors. How can that be? How can somebody who files a mortgage, which is a matter of public record, go out to defraud her creditors? And if it was a fraud, let's assume it was a fraudulent transfer. That's the powers of the trustee in the Chapter 13 case to avoid that fraudulent transfer. That would have been their obligation in the foreclosure case to add the mortgage as part of the foreclosure so that they could wipe it clean. They missed it. They're looking to blame everybody who's not at fault here. Their title company forgot it. They knew about the existence of the mortgage. They didn't do anything about it. But now they want to file a quiet title action. They want to proceed with that quiet title action on this veiled theory that there's some sort of fraud that was being committed by a woman who was simply trying to repay her parents for monies loaned. I realize I have a little bit more time. I'll take any more questions.
Apparently there are none.
Thanks, Your Honor.
Thank you. You have 3 minutes left.
Thank you, Your Honor. My client would submit that, yeah, this case would be a heck of a lot easier if the Youngs had been named in the prior foreclosure action. But that doesn't change what the issue is before this court. And unfortunately, my client being the purchaser, of this property, are they going to go and try and sue someone else? And it doesn't really matter. What matters is there was no adjudication of the validity of their loan. The issue before this court is not whether the predecessors to my client should have named someone in the suit, because the law is that even if they didn't name them in the suit, they still have the right to come and file the quiet title. My client still has the right to come and file a quiet title action later. Notwithstanding that, yes, things would be cleaner and easier if someone did something differently before. It doesn't strip my client of the right to have a quiet title action. They have a junior lien. It postdates the lien that resulted in the sale that resulted in the title to my client. The law is in Ohio that my client, even if those people weren't named, the law is they can come to court and file a quiet title action. And that's what they did. The issue in this case is not about that. In this particular appeal, it's in the case, but it was never reached by the trial judge. The issue in the appeal is when my client came to court to enforce that right to file a quiet title action, they didn't raise an affirmative defense of res judicata and then argued it. And the trial court said, I'm not reaching the merits of your client's claim, John, because of the res judicata. I don't have to think about whether a quiet title action is appropriate because of res judicata. And that's the issue this court's grappling with, is just res judicata. So my client is not trying to stand back and say, oh yeah, we didn't do anything wrong, or our predecessors didn't do anything wrong. It is what it is. We are playing the ball where it lies, so to speak. My client doesn't lose their quiet title action because nothing happened to their mortgage in the bankruptcy case. He said that my client acknowledged the validity of the mortgage in the bankruptcy case. That's not true. My client said they have a recorded mortgage. My client did not say it's valid. They said How could this be, he said this, how could it be that this was a scheme to defraud creditors? It's kind of not the issue. The issue is his clients have a junior mortgage, and my client has a legal right under Ohio law to remove it because it purchased under the first lien mortgage sale. But if you want to look at the facts, there are some in the record. It wasn't that the daughter and her husband were in business, it was the daughter and Mr. Young were in business. You know, we've cited in our facts section, he said he invested with his daughter to build this home as a spec home to sell it. There's no notes and promissory notes from back then. In fact, only one payment ever went to his daughter herself for $2,000, but now suddenly they have a $50,000 claim. I'll leave it to you to look at the facts on
And
that.
you have reached the end of your time.
Thank you, Your Honor.
Gentlemen, thank you for your presentation.
Thanks, Ron.